so far concluded. The interpretation clause, section 1 may the application of the where does the act applies operation, then interpretation clause, section 3, definition of code, fact, relevant, fact and issue, then very important definition of document, evidence, then proved, disproved and not proved, and section 4, which was very vital, that is may presume, shall presume, conclusive proof. So this much so far you know very well, isn't it? Nobody has any doubt, I'm sure, after hearing the lecture and plus seeing the record. Now today, this topic, if you understand, that is a relevancy of facts, especially section 5. You will understand what kind of evidence is required to be given, both in the civil proceedings and criminal proceedings, and what evidence is not permissible in both civil proceeding and criminal proceeding. I will take you through the Evidence Act, the provision, the CPC provision, CRPC provision, keep everything. Now this is a little tricky section. If you clear this hurdle, then the rest of the provision becomes easy. Okay? Now open your BERAC and see. Evidence may be given of facts in issue. That is the first limb. And relevant fact. So it is bifurcated into two compartments. You are permitted to give evidence relating to facts in issue. And secondly, a relevant fact. Now let us first understand what are the facts in issue. Now the facts in issue, which has been dealt under the provisions of Order 14, isn't it? Under Order 14, CPC, after the pleadings are completed, the court frames both the facts on law, facts on these are issues of facts and issues of law. Then under the CRPC, charges are framed by the criminal courts from section 211 to 224. 224. You know that, CRPC. After the completion of the charge sheet and copy being furnished to the accused person under 207. So you are permitted to give evidence, the plaintiff or defendant cannot travel when a plaintiff wants to begin his case and start giving evidence, which is under Order 18 CPC, he cannot travel beyond the pleadings and the issues. See, the court has framed several issues under Order 14. So, for example, take example in a suit for specific performance of a contract. Does the plaintiff prove that there is a valid and subsisting agreement between the parties, between the plaintiff and defendant? That the plaintiff prove that he has discharged his obligation under the agreement, or was he ready and willing to perform the part of his contract? Does the defendant prove that the defendant has committed breaches of the agreement? Is the plaintiff entitled to specific performance? That is from the averment of the claim. So the issues are framed not only from the averment of the claim, but also written statement. The defendant may take up the plea in the written statement that the defendant did not pay the money in time. Time was the essence of a contract. As a result of the non-payment, I have terminated the contract. So that the defendant prove that time was the essence of a contract, issue will come. Does the defendant prove that here that the agreement has been validly terminated? Then does the defendant prove that the suit is barred by limitation if it is taken? So these are the various issues that you know in the CPC. So I will not much go into it because you have learned about the provisions of Order 14. So when you see that here, Section 5 has to be read in conjunction with Order 14 and CPC, and Section 211 to 224, where charges are framed by the magistrate, judicial magistrates and the Court of Sessions and the High Court and the special judges. So you are permitted to give evidence relating to fact in issue under this provision here, number one. Then number C that here, evidence may be given of any suit or proceeding. See there, any suit or proceedings. The expression proceedings includes very wide. It may be a proceeding, it may be an application, it may be a dispute before several courts use different phraseologies. In the civil court, normally they use the expression suit. In the matrimonial proceeding, they say that a matrimonial proceeding. Before the consumer court, they use it as a dispute. And some places it is used as applications. So in any suit or proceeding of the existence or non-existence of every fact in issue, so you are permitted to lead evidence by virtue of Section 5 with regard to the existence or non-existence of every fact in issue, the issues which are framed by the civil court under Order 14 and the charges which are framed by the criminal court in Section 211 to 224 of the CRPC, and such other facts hereafter declared to be relevant and no other. And see, you are permitted to give evidence further in respect of those matters which are declared to be relevant. Now, what are the facts which are declared to be relevant is not given in this section, but they will start from Section 6 till later, Section 55. Okay, that will come. Section 6 to 55 deal with relevant year fact. And it says no others. Now you should know the meaning of no others mean. You should be able to point out and remember the provisions of the CPC as well as the CRPC in that regard. Now when you open, please Order 13, Rule 3 CPC खोलिए आपका. No other में मिल जाएगा आपको. No other में, yes, you will get it in no other. You will see Order 13, Rule Order 13 subclause 3 को खोल लीजिए आप. In the no other, this comes here 13.3, rejection of irrelevant or inadmissible evidence. So you should remember, you know that you learned it here. CPC cannot be forgotten now, nor can be given a go by. So you will have to mention while discussing the Evidence Act here, when the court doesn't permit evidence, under Order 13, Rule 3 CPC, the court has a right to reject irrelevant or inadmissible evidence. The court may at any stage of the suit reject any documents which it considers irrelevant or otherwise inadmissible, recording ground for such rejection. Now this exercise is done by the court when the court is passing order under Section 136. Please open Section 136 of the Evidence Act. Yeah. Just to decide.
Shall I try to present that?
Yeah.
Shall I try to put that on the screen?
Yeah, you can put it. Yeah, whatever sections I'm pointing out, please put it out. Section 136. No other mean when the court is rejecting irrelevant and non-admissible evidence. Yeah, please open section 136. Now here, yeah, I will put it up. So, before coming to 136, I would like to deal with also CRPC, because under CPC I pointed out to you where you are not permitted to, the court doesn't permit the evidence which is not admissible, rejection, that is order 13 rule 3. And now also please open provisions of section 294 CRPC. 294 college CRPC. Please don't forget your CRPC right now. Remember it. 294 भी खोल लीजिए आप. Now 294 says no formal proof of certain documents. Now don't go by the heading. Heading is misleading. Now read the contents. Where any document is filed before any court by the prosecution or by the accused, the particulars of every such document shall be included in a list, and the prosecution or the accused shall be called upon to admit or deny the genuineness of each such document. So, in the criminal court, this is the procedure where the prosecution and defense can take objection with regard to the admissibility of the evidence. You may tell before the learned magistrate or the learned session judge or the Honorable High Court that this particular evidence which has been brought is irrelevant. The document which is sought to be tendered is not legally, can be tendered by the court of law. So this is, you mention, you after inviting the court's order. Now this order is passed by the civil court under the provisions of order 13 rule 3 and the criminal court under the provisions of 294, taking recourse to one section in the Evidence Act, that is section 136. Now it is material to point out section 136, which should be read along with section 5 of the Evidence Act and order 13 rule 3 of the Code of Civil Procedure and section 294 of the CRPC. Now please kindly open section 136. Yes. Yeah, before 136, in fact 135 makes it very clear. The order of protection and examination of witnesses as per the provisions of CPC and CRPC, which I told you. Because you cannot forget CPC and CRPC while reading Evidence Act. They are three, or you may call it, they are three tires of the same car or three wheels of the same chariot. You cannot separate or segregate them. Now 136 is a very crucial section when the learned judge, when parties have completed the pleadings in the civil proceeding, first I'm talking, in the civil proceeding either in the Bombay High Court, exercising jurisdiction under the ordinary original civil jurisdiction, which is a district court, when a suit is filed under clause 12 of the latest patent, or in the city civil court Bombay, a suit which is governed under section 9 of the Code of Civil Procedure, or the Bombay Small Causes Court, where the suit is governed under the provisions of Section 33 of the Maharashtra Rent Control Act or Section 41 of the Presidency Small Clause Court Act for eviction of a tenant, for declaration of tenancy, for any order, or Section 91 of the Societies Act dealing with the society's provision, or Section 7 of the Family Court Act. This is the stage when pleadings are completed, plain and written statement. Normally, the court pass an order directing the parties for discovery, inspection, and interrogatories, and file their affidavit as a document. That in the CPC we learned it, we know. Once this is done, the court frames issues. The issues are filed, the issues are framed by the learned judges. See that when you see order 14, this is very important to again remember your provisions of order 14. From what material is required for framing issue. Order 14, rule 3 tells you the material for framing issues is that from the pleadings, number one, allegations made by the parties on oath in the pleadings, number one, then allegations of the parties in the interrogatories. Interrogatories are filed in the CPC under order 11. Now under the CRPC also, there are interrogatories filed. Can anybody point out the relevant section in CRPC where interrogatories are filed? Can anybody point out? Shall I point out? Section 287. 287 CRPC tells you parties may examine witnesses, parties to any proceeding under this code in which commission issued may respectively forward interrogatories in which the court may or a magistrate directing the commission. So here interrogatories provision is there. Please remember this here. Then thirdly, the contents of document produced by other parties. Now documents are produced by the parties under the provisions of Order 7, Rule 14 in the plain, and under the provisions of Order 8, Rule 1A in the written statement. Then the list of document is filed under the provisions of Order 13. Then under the CRPC, we right now learn the documents are required to be tendered under the provisions of Section 294, where the court may also issue summons under 1991. The parties voluntarily file under 294, interrogatories are filed 297. So here, the material issues are framed. But from the issues framed, the court direct the parties to then give direction that you lead evidence. Now, that lead evidence comes into picture. Now, either the plaintiff or the defendant may be permitted to, normally the plaintiff who filed the suit has to comment the proceeding. And that is the language of Order 18. Ashish, can you please open Order 18?
Yes.
Yes. Order 18 tells you that here, it is normally the plaintiff who has filed the suit. He begins right to begin he has got, unless the defendant admits the allegation of the plaintiff and contends that in point of law or some additional fact, the defendant is entitled to start the case. Suppose he takes up the plea that the court has no jurisdiction and the court is framing issue under 9A is now gone. Earlier 9A was in CPC for Maharashtra. Now under Order 14 Rule 2, that particular point is still the issue of jurisdiction. The court is at discretion to try the same as a preliminary issue, but not mandatory. Okay? That is the stage here. Normally the plaintiff begins the case. Now how the plaintiff begins the case? By filing an affidavit of document in the CPC under Order 18 Rule 4, that you see that here, under Order 18 Rule 4, recording of evidence begins. Please note that